This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a criminal, an insurance fraud criminal, became unhappy after making a deal to avoid a fraud conviction and found out that she had no right to change her plea agreement that was accepted by a judge, and why even after a defendant got a great plea deal, she tried to set it aside. Michele Seegars appealed from an order denying her motion for post-conviction relief, PCR, without an evidentiary hearing, claiming ineffective assistance of counsel at a plea hearing resulting in her guilty plea to theft of services. In State of New Jersey versus Michele A. Seegars, the Superior Court of New Jersey Appellate Division on December 30, 2024, found that Seegars' attempt to set aside a judgment was rendered as part of a plea agreement to a crime less than that which was charged as insurance fraud. In July of 2018, defendant was involved in a two-car motor vehicle accident in Kearny, New Jersey. After the accident, the defendant filed a property damage claim against the other driver who was insured by York Risk Services Group. York denied responsibility for the accident on the part of its insured, and shortly before the accident had occurred, defendant's automobile insurance coverage provided by Progressive Insurance Company had lapsed, and was not in effect on the day of the accident. On the day of the accident, defendant contacted Progressive seeking to renew her automobile insurance policy and falsely represented to Progressive that she had not been involved in any car accidents during the short period of time coverage had lapsed. Progressive determined defendant was involved in the subject accident during the lapse period and advised her by letter that her automobile insurance would not be renewed. Progressive, as required by statute, also referred the matter to the Essex County Prosecutor's Office for investigation for insurance fraud. Defendant Seegars was charged with third-degree insurance fraud arising from the alleged false information she provided to her auto insurance company in January of 2020. Defendant, on the advice of counsel, pled guilty pursuant to a plea agreement to a lesser charge of theft of services, a disorderly persons offense. The judge accepted the plea and imposed a sentence of 1 day jail credit and no probation imposed. The defendant, regardless, filed a timely pro se post-conviction relief petition. In further support of her PCR application, defendant presented 1, the 2 letters she received from York, and 2, an affidavit certifying she informed her trial counsel of her innocence before the plea. Defendant claimed she never had the opportunity to present evidence of her innocence to her trial attorney for review and investigation prior to the plea hearing. She stated that she thought her guilty plea was for a violation, not a crime. The state opposed the petition, arguing the documents submitted by the defendant were not exculpatory. In addition, the state asserted that defendant's affidavit was in stark contrast to her testimony at the plea hearing. After oral argument, Judge Callahan concluded that the defendant failed to present a prima facie case which would require an evidentiary hearing because she failed to raise any genuine issues of fact not already in the record. The Appellate Division, analyzing the issues, found that a defendant is not entitled to an evidentiary hearing if the allegations are too vague, conclusory, or speculative to warrant an evidentiary hearing. The Appellate Division concurred with Judge Callahan's finding that the defendant's claim of innocence was not based on exculpatory evidence and that no credible evidence existed supporting her position that the fault of the other driver excused her from disclosing the accident in response to the direct question from Progressive asking whether she was in any prior accidents before the date she applied for the policy renewal. The Appellate Division concluded, as the trial judge, that counsel's failure to consider this evidence was not a mistake that would have impacted the likelihood of success at trial and did not make it less likely the defendant would have entered the guilty plea. No evidence was presented by the defendant that the plea counsel affirmatively advised her that the guilty plea would have no effect concerning her future employment prospects. A review of the evidence considered by the trial court as part of the PCR application revealed the evidence against her was strong, and the likelihood the defendant would have been convicted on the original third-degree insurance fraud charge was highly likely. Therefore, the judge did not abuse his discretion by failing to hold an evidentiary hearing. Defendant failed to satisfy her burden to present a prima facie case requiring a hearing, let alone setting aside the judgment. In my opinion, every lawyer learns that it is important to be silent after you obtain a favorable ruling from a court. Seegars, facing a trial with a high potential for conviction and 5-year jail sentence, agreed to a conviction of a lesser crime, no jail time, no fine, and no probation, for which her counsel should have received a medal. She still obtained criminal conviction, however, that made it difficult to continue to work in her profession of banking. She was lucky the Appellate Division did not set aside the conviction, where she could then be tried and convicted of insurance fraud and sentenced to 5 years in jail, since she clearly tried to defraud her insurer, the Progressive. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,950 blog postings. Please tell your friends and colleagues about these blogs so that they too can subscribe to the blog and the videos. They're all free. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing for a very small fee to my Substack publications. Thank you for your attention.